Welcome back. This is Newsfile. It's the most authoritative news analysis platform, and here on Newsfile we put Ghana first. And you still have tons of messages on the first subject, but we have to go to the next subject. However, a couple of senior lawyers' messages I'll read. Okay, so Dafemopo should admit that the accused person is entitled to make efforts to fulfill the bail conditions, notwithstanding his protestations and the motion in court for review, and that application cannot be a fetter on the part of Wontumi to seek to comply with these conditions. Iyoko should proceed to inspect the documentation submitted and grant him bail if it meets the value. It is disingenuous to suggest that the hands of the officers are tired to proceed to grant the bail, and I am worried the lawyer has accepted this excuse. Okay, so this from a very senior lawyer. Another one also says that in criminal matters, because it is personal, Wontumi's wife has no authority to instruct another lawyer when his husband, the subject of interest, was still in touch with his lawyer and had not personally withdrawn his instructions. So, senior, we understand that it appears, the information we are getting is that and the Apia Kubi may be projecting that he's in contact with Wontumi, but he is not. So that's another angle that is coming. That whilst and the Apia Kubi was lawyer, has been acting as lawyer for Wontumi, you will see that when he came to Accra, it was Godfrey Dami who went to represent him, and the Apia Kubi told the media that it means that Wontumi doesn't want him to represent him again. So all issues, sort of issues are coming up. Okay, I think I can pause here and proceed with the next issues that we have to look at. And you're still here on Newsfile. This is your most authoritative news analysis platform. My guests are Roxanne Nelson, Eche Kwame Dafemopo, who is MP South Dai and Majority Chief Whip in Parliament, Hassan Tampuli, is MP Gushon and Deputy Ranking Member, Constitutional and Legal Affairs Committee of Parliament. I proudly handed over to him as President of the Ghana School of Law, SRC, James Kovena Bonfe, Junior PhD. He's CEO of Census and lecturer at UPSA. And let me say it because, look, PhD is not a joke. It's a whole lot of work. Those who want it cheap. It's not like that. Charlie, I just abandoned my Osman Al Hassan, private legal practitioner, and Kojo Pumpuni Asante is Director of Public Engagement and Partnerships at the CDD. So the Chief Justice herself on the 21st now issued a writ and had a number of reliefs that she was seeking. And then on the back of the writ, filed an injunction, went to the court, unanimously dismissed. The committee probing her should continue with its work. Let's hear from you, gentlemen. This time I want to hear from the governance person first. Kojo.
Yeah, the whole removal of the Chief Justice issue is really so many different issues around our constitution process. And I think that in a way, in a positive way, it's good that the CRC process is also happening at the same time, because I think some of the issues that it has raised, I don't think people have sort of put their minds to it. So, for example, the argument that's been made around the prima facie, issue, which I find it interesting because if you read the Constitution, when prima facie is used in this context, it's really just like an Iyoko making a preliminary determination that should I go ahead and investigate this matter. It is not in the court sense of some sort of a legal standard for saying that is there enough evidence for me to go forward and adjudicate this particular case. But in a way, the way the lawyers are talking about it, it seems like the two have been, it's almost like it's considered as a judicial process, right? So the question about should the Chief Justice have seen the reasoning of the President and the Council of State on why they decided to make a determination of prima facie, and then, proceed to propose or recommend that she be suspended. And that is a question, because if, I think those who have even looked at like the Kenya one and so on, it just basically doesn't even use the words prima facie. It just basically says, on the face of it, these allegations that are put, are they substantive enough for you to investigate? Because the body that is supposed to be created afterwards is an investigative body that then comes to a determination and make a recommendation, to the president one way or the other. The second point is that the issue of suspension, which in a way is also then presented as a punishment, almost like, because you have made a prima facie case, we feel that you have done something wrong and therefore we are punishing you by suspending you. But the suspension, you could have easily substituted that with recusal. Because of the particular nature of the process, you are talking about investigating a Chief Justice. The idea that the Chief Justice, once you have determined that you should go further to investigate, will still be sitting on cases and exercising her powers as Chief Justice, creates so many problems for conflict of interest, for ethics, for whatever. So it makes sense that you will say, recuse yourself whilst this process is going on. So for example, in this case, Justice Tukonu, just before the suspension happened, was the one that empaneled the judges that were supposed to hear, I think the first case, the Asafwa case, for example, right? So how would she have played that role if she was still in power for all these cases that have come? That she will be empaneling justices to go and hear cases injuncting the process that she is currently being investigated for. So I think that there are like problems with the way in which the whole process has been structured. But how do you correct that while the process is going on? It's almost like you can't stop midstream and address those challenges, as it currently stands. So for me, I don't think those who make the case of a prima facie, I think the way they are judicializing the process too much, and I don't think there's merit in it.
The point is that precedents show, and I have the benefit of being involved in at least two situations. The precedents is that they would normally give a reasoned decision in the prima facie. So the prima facie can be 3 pages, 4 pages, but those I have seen, they are more than that. Sure. Mm-hmm. And you can read, and you will see in the prima facie that it says, your accuser says you have committed 10 sins. Mm-hmm. We find merit in 2, 3, 4, 3, 4, or 5 of the sins. Yeah. The others, we don't think they are. So now the committee has been set up. You come and you respond to those that prima facie has been made. That's her concern. Sure. So now you say I should come. Sure. And I don't know which ones I am answering to. Is it not fair?
So that's what I was saying, that for me, the way I understand it, and what has happened since the process began, is that we are almost imposing setting standards in almost like we are in court. You see, if you look at the way the Constitution is clear, that's why they didn't say the Chief Justice should, it should be a panel of judges that should sit on they said you should bring people who are not loyal, who are not this. This is obviously intended to be a process that is not judicial, or one would say it's quasi-judicial. So there are processes that at the beginning that you would say that if the president and the Council of State did their whatever preliminary, whatever, made their determination, and at the investigation stage, the investigators came and said, oh, this is the issues that we are going to deal with, right? They didn't give it to you at the time of when the determination was made. You are not going to say, well, because I didn't receive the reasoned judgment, therefore the process should be vitiated. That is where I'm having a problem with, because I think that once you do that, it means that even at the prima facie case, you can go to court and now start to interrogate or dispute the reasoning. Because what will stop the Chief Justice, for example, after receiving it, to go to the person and says, I don't think the grounds on which they made the prima facie is right, and therefore I am challenging it.
She also wants a public hearing. How about that?
No, so the public hearing one, so we know that the law, at least what I've read, is very clear in terms of the fact that it should be held in camera. The argument she's making is that somehow she has an inherent right to, or inherent right, I don't know whether it's a right of speech or whatever, that she can waive. I don't think the Constitution does that. I don't see anywhere in 146 where that right is given. If that right is a general human rights, then maybe you can go to the High Court and say that even though it has not been introduced in the process. But it is not just about her rights. And this is the other thing that we have to accept about the 146 issue, because the issue, even with the high security and the challenges she's having with the security screening and all of those kinds of things, is that particularly because when this case started, the leakages has been so rampant that if you were going to succeed in holding it in camera, you needed to find something that is secure. She was saying that ordinarily is held at the court premises. But that was cases where she, as Chief Justice, she was the one conducting the investigation.
Or other Chief Justices.
Other Chief Justices exactly conducting it. But this is involving you.
They were not exactly conducting. They were only
the one that were, yes, basically, right? So it was under the supervision of the Chief Justice, one would say. So for the Charlotte Osei one or even the other one. But in this case, of course, it's you who, another committee that necessarily is not sort of the purview of the...
So why do you take it to an abandoned castle, abandoned presidential...
I don't know.
Abandoned slave dungeon or slave...
I don't think... Annex. I think I've been to the office of the president annex, I think when it was being used, and I don't know which rooms they are, but I don't know when they say it's cruel, like the environment. I don't know. I don't see... What is it about the room? Treated like she's committed some treason of sorts. I've seen what...
That's where she stands.
I've seen how the people who were brought for treason, the police officer said, there's no anything like that. I think and just to try and wrap up, what I worry...
People may be surprised hearing from you, because you wrote an article that, sought to uphold her rights.
No, my article was very clear. My article made the point that the issue that we have in terms of whether you have perception of bias of the Chief Justice is not the person that is there that is the problem. It is the governance framework we have set for the Chief Justice, that if you replace this person with another Chief Justice, you are going to have the same problems, because the discretionary powers. And so I think that for me, that point, but it's the issues that are being raised now, like if, for example, you are before a commission of inquiry and you think that there are problems with the rules that have been set, how do you address it? Are there mechanisms within the commission of inquiry rules that allow you to address it? Like if you say, I feel intimidated, or I feel that I would like this room, the committee can decide yes or no. At that point, can you go out of the process and say, go to the Human Rights Court and say, no, I cannot bear this, like I can't continue in this way, and therefore intervene? I think that is where it's an interesting legal question, because this process is final. unlike other processes where you can appeal.
You can't even allow her husband to keep her company in the process.
Yeah, so within that process, that's what I'm saying.
From where you said, can you tell us what is lost if her husband was allowed to be with her?
I don't have
at least not her daughter, but not her family, but just the husband to be with her. I
don't have any problem because I think those are something I'm asking myself, that in the committees, the committee is supposed to do its own rules, right? Of course, consistent.
Only the parties, the accusers, their witnesses, the accused, quote unquote, the respondent, and their witnesses are allowed, and their lawyers are allowed.
Yes, that's what I'm saying.
If you make an exception to allow her husband,
that's what I'm saying. The committee, those things are very basic, and I don't understand why they exclude that, right? Even the question about whether petitioners themselves should present themselves rather than their,
witnesses.
What you would think that, yes, I want to face my accuser, right? Somebody has that right you want to make. So, but what I'm saying is that when that is going on, in a process where you cannot appeal, right? How do you deal with that? Because once the process is finished, you can't go and say you are going to appeal in this particular case. In other processes, you can go back and say, because of what went on, basically vitiate the
unanimously, the supplementary statement, which had all these complaints, was thrown out.
It was thrown out
because it was disclosing the private issues.
So, which is a very narrow way.
Was your expectation that this will happen?
No, this is almost like a technical
knockout,
a withdrawal of the jurisdiction of the Supreme Court. The Supreme Court is saying we cannot enter into. So the matters that are even being discussed has not been touched at all.
Okay.
But the point I just to finish off was that certainly this process has flaws, and we need to find ways to deal with it. The only issue is that as we are now, there's no way in which you can stop this process midstream.
All right.
In order to...
Right. So we have been told that new rules are coming up by Parliament. Yes,
which
James.
I don't know how that's happening.
Yes.
Well, for me, because I'm an interested party, I'll be careful. But it appears it appears that
cannot do that in mystery.
A political decision was made, and we are working towards that. That's how it seems to me. Dr. Asante makes a point. It is very clear from the work of the Constitutional Review Commission's work in 2011, Professor Fiajo, Emeritus Professor Fiajo's work, the government white paper, and I think the Ajichun case, that Article 146 is nebulous in nature and needs a reconstruction. This is something that, the cited authorities have said. The president has set up a committee to advise him on how to proceed with the constitutional review process, or a constitutional review process, and that is ongoing. They are yet to come up with their work. So I was hoping that we would be measured, or we would be guided by this kind of background, and a bit of history will do. Perhaps maybe that's where I would disagree with my brother Asante. That if you look at the Ajichun case, the Ransford France case, Justice Derry versus Tiger PI, and then the recent one, Gregory Afoko 2019 case, the Supreme Court has said that a prima facie, and in fact, the establishment of prima facie against the removal of Mrs. Charlotte Osei, Mr. Amadou Sule, who is late, may God take his soul, and then Madame Georgina Opoku-Amankwa, a certain standard has been laid as to how prima facie is established. And if you read what Dr. Barnes said in the Ajichun case, for your permission, with your permission, let me read that. He said, in respect of Article 146, if once any petition, no matter how frivolous its contents are, is presented to the president, then he has a duty to establish a committee to consider it. A literal reading of the provision, therefore, could lead to the floodgates being opened for frivolous and vexatious petitions being continuously filed against a serving Chief Justice, with 2 Supreme Court judges being perpetually tied down to hearing said petitions alongside the other members of the committee that the president has to appoint. This is a scenario that would weaken the efficacy of the top echelon of the judiciary. And I mean, it goes forward to prescribe a way that in establishing prima facie, some weight must be put on the petitions that are brought. And we look at the situation in 2016, that the Chief Justice then, in considering the petitions that have been brought, in fact dismissed a number of the allegations and admitted or sustained a number of them, and then proceeded to form the committee. If you look at that narrative and look at what has happened so far, I think that is what senses is in court, seeking interpretation and also enforcement, that if certain things are done, perhaps one would conclude that the way we have come is in error and we need to arrest that. The issue of
public hearing.
The issue of public hearing. What is in the petition or those petitions that is already not in the public domain?
Are they in the public domain lawfully? Is it a breach that they are in the public domain or not?
In my view, in camera, in Article 1468, should have been the case for the receipt of the petitions, the consideration through all the entire process, and then to the committee throughout.
Good.
I doubt if that has been the situation.
As in,
who has done what?
It is not the who. It's about what has occasioned, what has been occasioned, or what has happened, or what we are experiencing.
If something was leaked, was it leaked lawfully? Who leaked it?
But the point is that it's leaked. It's out there in the public domain, and other things have been added.
Therefore,
and that is where I think that what.
Therefore, the Constitution should not apply anymore.
No, I didn't say that. What, in essence, the Constitution is a paper. It's a document. The law is as good as the people invited to obey and administer it. The integrity of people who interpret, people who obey, is also as important as the law itself.
There should be a public hearing.
Well, I am not there yet. I mean, I don't think we are even making an issue of the in-camera thing. That is not part of.
It's important. It's part of what she's
you want to talk about that.
That's what we are talking about. It's the case that
for me, even before we get
the injunction application that we are here.
Samson, before we even get to the issue of 1468, I am talking about 1466. The need to establish prima facie.
You concluded that.
If we have not done that, you cannot jump to 2 when you have not done 1.
You have finished that argument. And so we need to move on because of time.
Yes. So that's why I want to skip that. And I say that given the consideration, the wide public interest in this matter, what do we lose if this matter is
you breach the Constitution.
We breach the Constitution.
Deliberately.
Yes. And as far as I'm concerned, I don't think that the in-camera hearing means that non-disclosure to the public.
Does it matter that the same court, Supreme Court, has held that the in-camera hearing is mandatory? You can't do anything about it. Does it matter?
And I think that in the Derry...
not in Derry. This was in the Ghana Bar Association
in Derry,
versus
in Derry he pleaded,
case.
No, Derry pleaded that the in-camera thing had been breached. The court held that, notwithstanding the airing of
it doesn't invalidate
the issue. That's the point I want to lean on. That at this stage, once the matter has become public, making sure the entire public is kept doesn't take away any.
So the court should go and endorse the illegality and the unlawful things that have happened.
I have not said so. I have not said so. This is a matter that has generated public interest. At the end of the day, her spouse issues and all those things, I don't want to go into them. What I believe is that dealing with the Chief Justice and her removal, or the removal from office of the Chief Justice, has weightier impact on our constitutional dispensation than the way we are considering it or the way we are going about it. And if we went about it properly, I don't think we will be here. Thank you.
Okay. Thank you. Roxanne.
Yes.
So she makes one point where you could say that's a very important point.
In fact,
because if you said, hold on, if you said, as for prima facie, there are no hard and fast rules about it. Like Dr. Pomponi said, I can determine the way I want to do it. I can decide that I'll just write one sentence or one line and say a prima facie case has been made. But she says that some of the allegations against her, some of her peers, the judges sitting on the committee, were on the panel of those cases, or they have dealt with some of those cases. So let them recuse themselves, reconstitute this committee. That's why you dissolve the committee, because Justice Poaman, Justice Adibu, they have dealt with some of the cases. What if somebody wants to call some of them as witnesses? And in fact, one of them has indicated that if he's given the opportunity, he will call one of them as a witness. Imagine that the chairman of the panel is being called a witness. Is this not some place we can all agree that it's a fair point she's making in the court?
But we just
let's hear him. I'll come to you.
Okay.
Now, it may be a fair point if it's demonstrated that it will have some prejudicial implications for the outcome. But the standards for that has been set long ago in Salah versus AG, number 2. So that was edge on the court. Now, this prima facie determination debate is a principle or the law that confers as in Act 30 in criminal prosecution. The prosecutor, when the complaint comes, the prosecutor doesn't straight go to court. It's mandated in law to make a prima facie determination. Then he will charge. No standard was provided as to how that should be determined. Then this found its way in the Constitution. This was a provision that was hardly used until within the past 10 years or so. Now, the debate has been whether or not some guidelines should be provided. So, Adechum clearly has the decision provided some guideline. Now, the concern of the CJ for me is it's a concern that I think can be dealt with when she's giving her testimony. Why?
For the committee.
Because you have been provided with a copy of the petition to respond to, and you did. And after that, a prima facie determination was made. So all the matters that you responded to within the gamut of all the petitions are now in your bosom. You have answered the issues one after the other in your response. Notwithstanding, the decision has been made that a committee should be instituted for you to come and speak to the matters. So, if I were her, I'll just carry the response I gave before the prima facie determination.
Go to the committee.
And deal with it before the committee. If there's a need for me to provide further and weightier materials to support my objection to the petition being heard on its merits, I will do.
What I know is that often the main petition and then the response that is brought, they form the basis of the committee's hearing.
Good. So that becomes, like in parliamentary language, that becomes the travaux préparatoires, that becomes the basic documents the committee will deal with. So I'll be prepared on all the matters that are contained in any of the petitions adequately. Indeed, if there's a need for me to provide further information, like I said, you always ask for an adjournment. Or you prepare in such a way that during cross-examination of your accusers, you put those matters across. Okay. The other issue, which for me falls within Order 20 Rule 9 of CI 47, is the content of the affidavit that the court...
Supplementary.
Yes.
So in actual fact, let's let our audiences know that affidavit is as if it doesn't exist. Because it doesn't form part of any process in the court.
It took a judicial process for that to be hacked.
Okay.
So the contents were vexatious and scandalous. So the court thought that we can't proceed with this.
No,
that's not the reason.
They breach the in-camera requirement.
Article 146.
That's why it was.
That
was what the court based on its decision.
Yeah, because you have attended an in-camera process, which nobody is supposed to know, but you have brought information from the in-camera to the court.
But you see, under CIA 4728, content of an affidavit, you can, as somebody deposing to you, can actually speak to a matter when it is a matter of fact. So there I would disagree with the court. My problems with the affidavit was rather it was vexatious. Some of the matters were simply not necessary to confront the court.
Which one?
Like saying that the walls around the place was high security. I mean, what has this got to do with they were not necessary.
It's a statement of fact.
Yes, but
you just said that she can allude to statement
so
of fact.
I'm saying that Bet 9 will tell you that these are vexatious. You don't come to court with this matter.
Vexatious?
Yes.
How can that be vexatious?
When a proceedings is held in a premises in a secured premises.
Wait until you find yourself hold up in a very high wall.
But Castle is a presidential. It's an annex to the presidency.
Oh, really?
Yes, but it is. Not really. These are matters of state.
And the Chief Justice has been hauled before a facility like that?
But there has been the president who sat in the castle and governed this country for nearly 20 years. Hold on.
These proceedings could have taken place at the Jubilee House.
Good. But I'm saying. No, but hold on.
What you are saying?
Hold on.
Do you remember where
this proceedings actually taking place?
Do you remember where the Ayawaso were gone? Ayawaso West were gone. Hearings were held. That's where it was held.
But that one is a public thing.
Okay.
It's not about public thing.
Yeah, but but everybody processes situations differently.
And there were people,
she's feeling a trauma. She's feeling certain trauma over this process. A lawyer is not being allowed and all of that.
Very restricted facility.
Okay, quickly.
Restricted.
The point was made that all previous proceedings were superintended by the CJs. So they found the judicial court premises convenient. Do you know how people fear to enter court premises? Do you? You have no idea. You are a trained lawyer, so you take it whimsically. You take it for granted. There's some heavy sense of trepidation when people are in court premises. But they were gone there. Now, Justice Derry and co, they were not even giving copies of their petitions. They even went to court to ask for it. They were not giving. Prima facie determinations were made. They went to court. They tried to injunct it. They were in court over 80 times. It never happened. So this Article 146 issues, we can all sit down and say that we can look at it. But by all means, that is the provision in the Constitution for dealing with this matter.
Right.
The CJ herself had mandate under law to discipline other lower court judges. She recently disciplined a Jessica Circuit Court judge. Why? Somebody brought a petition on grounds of misconduct and abuse of power. What did she do? She referred it to the disciplinary committee of the Judicial Council. They went into the matter. They made adverse recommendations against the judge. Based on that, she, as the head of the Judicial Council, with the legal architecture available, she fired the judge. The judge went to court to challenge it, though. But the CJ exercised their powers.
All right. Thank you, Roxanne. And this program or show is brought to you by the Canada sponsorship of Bank of Africa, as strong as a group and close as a partner, MTN everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, dial *165# on MTN to join My Way today. Flamingo Paint, simply superior. Syntex Tanks, it's strong, it's tough. Activa International Insurance, our clients, our passion. And International Facilities Management Association, they are proud to be associated with Newsfile. And my outfit, as always, by Konati Clothing. You can call them 0244 676732. Konati Clothing, 0244 676732. And ahead of the Muslim festivities and the holidays, they are giving you a 10% discount. So just call them and they will make you look good. And those of us who have friends who are Muslims, it's not all the time that you should wait for them to do and bring you meat. You can look for a good shirt and give to them.
Waiting for. That's the only way.
So just call 0244 676732 and Konati Clothing will make your friends look good. Yes, Hassan.
Yeah, so 2 days holidays.
Yes, Hassan Tampoli.
Yes, sir.
Yes, so did you expect that? Some say what happened in the courtroom should give you a sense that the judges particularly they have decisional independence, that they looked in the eyes and in the faces or in the face of their boss, so to speak. Of course, they are equals, except that one becomes a chief justice. And they looked in her face straight. She was sitting there. I entered the courtroom and my gaze was on her. And they said, "You are wrong. First time, second time, you are wrong. Unanimous, everything gone."
Samson, I think that this matter is one that is bringing some amount of doom, putting some huge damper on our constitutional democracy. Ever since 1963, when Justice Seyaku Kosa was removed as Chief Justice by the Nkrumah regime, this is the first time that we are seeing a Chief Justice being shoved aside in the manner that the Chief Justice, Justice Tokonu, was put aside. There have been instances where issues of, removal of Chief Justices have been raised, but this is the first time after Seyaku Kosa. Even during the military regime, we have seen military coup d'etats have taken place, but the judiciary continues to remain the united factor as far as, this country, Ghana, is concerned. So after the military coup d'etat, the executive is deposed, parliament is dissolved, but the judiciary continues to remain. And we have had instances where Chief Justice Apalu, for instance, has served under different regimes. Military coup d'etat comes in and then he continues to be in office. Another one comes in, he continues to be in office. All the way, he served under 3 regimes. One in Dr. Hilal Liman and then 2 in different military regimes before Dr. Hilal Liman and then during the Rawlings regime. So if you look at the Constitution, it's not for nothing that the framers of the Constitution have made some provisions under the judiciary. What's the name?
146.
Independent
constitutional bodies.
Yes. So those provisions that are not easily amendable.
Okay, entrenched.
Entrenched provisions. Article 125, Article 127, Article 145, and 146 are the only entrenched provisions under the entirety of the judiciary. And so they should tell us something, that these provisions are put there based on our history and as a future guidance as far as this our nation is concerned.
So what? They should not be used if people trigger them.
So they can actually, and the Supreme Court has said it plainly in the Jichum case that notwithstanding Article 127 on judicial independence and so on.
My apologies to Osman in advance. We have only 2 minutes to end the show.
Article 127 and all of that. Article 146 continues to endure. But what is important for me is that I have seen 3 petitions. The one from my own classmates at the law school, Yakubu Ayamga, the one from Daniel Ofori, and the one from Shining Stars. Now, all these petitions, if you look at the heading, petition for the removal of Chief Justice, this is Ayamga. Petition for the removal of Honorable Chief Justice, that is Daniel Ofori.
And then the last one, shining star, petition for the removal of Chief Justice of the Republic. Now, are we saying, for instance, that these petitions,
You have the petitions.
that's why we said that this matter should be put out in the public domain. Are we saying that
You are saying that the Supreme Court should violate the Constitution by saying that where some people have done a wrong, you should go ahead and endorse it. Is that what you're saying?
You see, are we saying, for instance, that it's enough that we give effect to Article 1468, even in something untoward is happening? Are we shutting the door of justice to anybody because the Constitution says that it must be done, in camera? Where is the justice of this matter?
All right.
The Chief Justice has approached the Supreme Court's fountain of justice.
I'm sorry, but this all time
as
will
a
allow
humble
us for,
supplicant to
this,
her colleagues,
this all time will allow us
that
for
my
this
rights
very
are being
afternoon.
violated.
I'm very
the trial
sorry.
is being
My
undertaken
guests
like
have
an
been Robson
ACDR
Nelson,
matter.
Eche Kwame Dafiama Paul, Hassan Tampuli, James Kwabena Bonfe, PhD, Osman Al Hassan. My apologies to you, and then Dr. Kojo Pumpuni Asante. Thank you very much. But when are the rules you are going to make? When are they coming out?
Something. You haven't cheated me. This matter.
I'm sorry.
My say is the most important. My say is the most important.
Yes.